everyone. Thank you for attending the Society of Product Safety Professionals webinar series. My name is Lauden Harp, and I will be managing the production of this webinar. If you're having trouble with Zoom audio or visual, please send a chat to the host, and I will be sure to respond as soon as possible. If there's time at the end of the presentation, we will have an opportunity for Q&A with our speaker. If you have questions during the presentation, please send those questions via Zoom chat. If we don't get to all the questions, we will review and respond to all the questions via email after the webinar. At this time, I would like to introduce Laurel Roney from Swimways Corporation, who has put the SPSP webinar series together, and will introduce our speaker today.
Thanks, Lauden. Once again, I would like to welcome you all to our SPSP webinar series. We truly appreciate your continued support of our program as we explore topics that we, as product safety professionals, all face as we work to establish and maintain successful programs that comply with both regulatory requirements and industry-leading practices. It is our goal with this webinar series to continue to feature topics that support the development and maintenance of a comprehensive product safety program. We are very excited about this series and would like to thank our exclusive sponsor, Stericycle, for their support in making it possible. And now I am so pleased to introduce today's speaker. Will Troutman is a partner in the Los Angeles office and the head of Consumer Markets US for global law firm Norton Rose Fulbright. His expertise includes regulatory compliance for consumer products, food, cosmetics, and automotive parts, compliance and enforcement for chemicals and pesticides, including Prop 65, Superfund and other environmental restrictions, and supply chain dynamics involving human rights and CSR issues. Will, we are so pleased that you have agreed to share your insights with us today, and so at this time, I will turn the presentation over to you.
Thanks so much, Laurel. Thank you all for having me here today, and a special thanks to the Society of Product Safety Professionals for allowing me to be part of this wonderful program. In my work as a product safety and compliance lawyer, one of the biggest issues confronting my clients is how to build and maintain a compliance program when state, federal, and local requirements overlap, intertwine, and are continually changing. This seems to be of biggest concern in the context of chemical requirements, as there are requirements or possible requirements at all three levels, and they are a hot mess. I mean, we're not even talking about international requirements, just US today. Over the next hour, we're going to talk about ways to approach this issue. As we go through the material, I encourage you to ask questions through Zoom chat. We will do our best to get to them either at the end of the session or afterwards via email. One call out. Based on the attendee list today, we have a good mix of manufacturers, suppliers, and retailers, as well as supporting professionals. Given the differences in supply chain positions, some of my comments will hold most true for one or the other type of business, but I will do my best to give something useful to everyone here today. So at the most basic level, it seems like dealing with federal, state, and local product chemical laws should just be a matter of knowing what the rules and requirements are. But as I'm sure many, if not all of you know, chemical requirements entail many moving parts. Here, not only do we need to understand what the rules are, but we need to appreciate the types of jurisdictions, enforcers, responsible entities, requirements, and risks. All of these components feed into approaches for compliance. And over the next series of slides, I'm going to put up some graphics meant to just really terrify you and confuse you. So at the first level of risk, or first level of understanding, we have types of jurisdictions. So we have federal, state, and local laws, regulations, and ordinances, but within any legal structure, you have a progression from the high-level law or ordinance to the implementing regulations all the way down to agency guidance. It's crucial to understand this progression, as oftentimes the regulations and guidance significantly change the way you would otherwise understand the law. Typically, if you just read the law, you really have no idea how to implement it. And beyond regulations, agency guidance from the agencies who are primarily responsible for administering the law and regulations usually address implementation problems that weren't anticipated at the statutory or rulemaking stage. And finally, while I'm not going to talk much about them here today, you also have to consider industry standards, as they frequently serve as stand-ins for formal laws and rules, and also can be key in product liability litigation. Another important consideration is whether you sell only in stores, online, or both. If you sell online, you could be subject to requirements of all or nearly all jurisdictions, whether you know it or not. On the other hand, enforcers may be less focused on online entities only, or may not be able to acquire units for investigation, et cetera, like they can if they can just walk into a store down the street and buy something. At the enforcer level, with all of these various jurisdictions, you also have a multitude of enforcers. Most directly, you have the agencies authorized by laws and ordinances to enforce these requirements, which I just went over jurisdictionally, but oftentimes, especially at the state level, you have laws that do not give specific authority to any obvious agency, or they may authorize agency administration, but don't contain penalty or enforcement provisions. For whatever reason, and for many different reasons, our legislators pass vague, confusing, or often impractical laws, as I don't need to tell all of you. Sometimes it's because the only way to get to yes is to compromise certain issues and leave vague and ambiguous parts of requirements. Sometimes it's because legislators want the upside of publicizing a law but don't want to be held responsible for unintended consequences. And sometimes, of course, it's because legislators don't know much about the realities of the industries they regulate. As a result, there are a number of laws for which the responsible agency does not have enforcement authority, in which case state attorneys general, district attorneys, or city attorneys may threaten or bring lawsuits on behalf of agencies. For any of you who do business in California, a great example of this is the California district attorneys, as they, on an annual and sometimes quarterly basis, get together and determine enforcement strategies and priorities for enforcing various compliance laws on the books. Some of the cases may be brought directly under the relevant law, but be aware that there are often complementary laws that give even greater authority to the enforcers. And again, pointing to California, which will be a recurring theme here today, you have California's unfair competition law, which amplifies penalties and gives the potential for attorney's fees in connection with compliance issues. And beyond public prosecutors, some laws allow private plaintiffs to enforce, and these include laws with what we know as private attorney general provisions, like, again, California and the dreaded Prop 65. And there are others that may be enforced through product liability or class actions, and particularly under unfair competition or false advertising theories. Also, just before we move on to responsible entities, I do want to point out that beyond the specific enforcement issues, you do have the potential for reputational risk. So depending upon the type of company you are and where you sit in the market, sometimes you may be concerned with or driven by reputational risk in the market rather than specific enforcers. So next rung in the chain of thinking about compliance, just after you get a sense of what's required and who can come after you, there's the question of who's responsible. Some laws identify a responsible entity, while others apply to everyone in the supply chain. For example, CPSIA applies to the manufacturer or the importer. Prop 65 applies to any person doing business in California, although we now have responsibility allocated to establish priority. But definitions and guidance can often twist what seems straightforward. Another example, Washington's definition of manufacturer under the Children's Safe Products Act doesn't always mean the company or factory actually making the product. If the manufacturer, the true manufacturer, is overseas, the definition of manufacturer under that law includes the importer or the brand holder. And Washington guidance sets forth a hierarchy that the state follows when enforcing. So it's really important to focus on the language of the statute, but then also look and see if there's further guidance. And then beyond what's actually in the law or the regulation or the guidance, there are practical implications. Just as a matter of practicality, it's very difficult for enforcers to pursue overseas entities, and they don't really have the appetite for it. It's also typically fruitless to pursue what, air quotes, a mom and pop shop, an intentionally undercapitalized distributor or a bankrupt entity. So sometimes an enforcer may come after you because you're the deepest pocket or you're still in business. And often, even when the law is clear, or when our understanding of a vague law is clear, supply chain realities come into play. So, for example, under Prop 65, even if a supplier is exempt, if its retail customer is not, the retailer is likely to pursue defense and indemnity under the contract between the parties, in which case, technically, the supplier is not the liable party, but they may step in and have to resolve it to avoid a dispute between their themselves and their customer. So in terms of product safety laws, there are also all sorts of requirements, and we see this particularly in the chemicals perspective. You have examples or types of products that are types of requirements and laws that limit composition, they limit exposure, they limit labeling, they might require fees and taxes, they might require labeling. I've listed out some of the potential types of requirements here on the slide. To give some examples, CPSIA limits composition. Prop 65 limits exposure. We can talk about that in a little more detail later. CPSIA and Prop 65 also have labeling requirements. Pesticide laws have licensing and registration requirements. Prop 65 and other state chemical laws may have warning requirements. The various state children's product chemical reporting laws, as their name states, require reporting. CPSIA also has record-keeping requirements, and there is a growing trend towards state product stewardship laws that start to have end-of-life management requirements in them. And those same state product stewardship laws may also have fees and taxes. And with the California Safer Consumer Products regulations, you have a requirement for alternatives analyses, and with a recent Washington law, it looks like they also are going to go the route of alternative analyses. So finally, after you get your handle on what the law requires, who's responsible, the question is, what's the risk? So risk is not just that an enforcer may seek money from you, but instead a multi-layer issue. First and foremost, you have the health and safety of the customer. And you know, beyond that, you have the potential for investigation. So nothing more than an inquiry from an enforcer can have significant costs. These include investigation, business disruption, cost to pay lawyers like me. Even if at the end of the day, you didn't do anything wrong, you may still have to pay money for proving that you didn't do anything wrong. If you have a product problem, you have costs associated with stop sale, recall, repair, testing, developing a fix, failure analysis, logistics, and refunds, among other possibilities. And if you're a supplier, there are potential costs to indemnify your customers. If you are the supplier or retailer, the costs associated with quickly finding replacement product for empty shelves are the losses if you can't. And more generally, you also face reputational risk. So we have a proliferation of product blogs, social media focused on product safety and compliance. And for those of you recently reading about product safety news, we have the Washington Post. And of course, there's direct risk of loss from civil or criminal penalties under enforcement. Fines in terms of monetary perspective, but also potential for an agency or government enforcer to require specific compliance efforts and potentially oversee those compliance efforts. So that is the context for looking at these chemical requirements from the multi-jurisdictional perspective. All those layers feed into your approach. So let's spend a little time now to go over some key chemical compliance regimes and discuss how they overlap. Chemical requirements is an area of product safety in which you have multiple layers of federal, state, and local requirements that are continually changing. Just a disclaimer as we go through this, this is not an exhaustive list. This is more of a most common review. Depending upon your company's product mix, other chemical requirements may apply. For example, FDA requirements for food and cosmetic products, labeling and warning requirements for chemicals under the Federal Hazardous Substances Act. Second disclaimer, I'm not going to be talking about the Federal Toxic Substances Control Act, which was recently amended. The reason for this is that so far, we're not really seeing, even in its amended form, that it has much direct impact on at the consumer product compliance level. So first, I want to quickly go over the Consumer Product Safety Improvement Act, as I see this as the federal law having the greatest impact on chemicals and products. The CPSIA amended the Consumer Product Safety Act and the Federal Hazardous Substances Act. This law requires domestic manufacturers and importers to certify that products subject to federally enforced consumer product safety standards comply with those standards. The U.S. Consumer Product Safety Commission is responsible for implementing these requirements. From a chemicals perspective, the key provisions of the lead and phthalates limits in the toy standard, as I'm sure most of you are aware, CPSIA requires testing and certification for lead in children's products and furniture, 90 ppm limit in surface coatings, 100 parts per million in substrates, and it restricts phthalates in children's toys and childcare articles to 1,000 parts per million. And there's the laundry list of phthalates that are on the list so far. I think we can expect that that will continue to grow over time. And then finally, the ASTM F963 standard, which CPSIA codifies into law, applies to toys. And from a chemicals perspective, it limits the amounts of soluble heavy metals in toys, surface coatings and substrates, and there's a list there of the heavy metals that are covered in particular. One thing I want to point out that's a key consideration here, and that's going to be a recurring theme as we move through these requirements, is that the lead and phthalates requirements are composition limits. They limit the amount of the chemical that is in the product. The toy standard, in contrast, is a limit on how much of the identified chemicals come out of the product. In this case, how much comes out under conditions simulating a child sucking on or ingesting the product. So as you think about compliance, it's important to focus on what the law is actually requiring, because that can change how you approach if you're the retailer, how you think about what you require from your suppliers. If you're a supplier, how you source your raw materials to make and manufacture your products. In addition to the testing and certification requirement, the Consumer Product Safety Act contains the Section 15B reporting requirement, which requires that a company report to CPSC upon obtaining information that, as we list out here, reasonably supports the conclusion that a product does not comply with the Consumer Product Safety Rule. So that would be the lead and phthalates limits we just talked about, or the ASTM F963 standard, or contains a defect that could create a substantial risk of injury or presents an unreasonable risk of serious injury or death. So you have a two-pronged situation here. You could have an issue of objective non-compliance with a standard, but you could also have the subjective and squishy issue of whether a product contains a defect, for example, contains chemicals it's not supposed to, that potentially create the substantial risk of injury. This is a pretty unique approach to compliance, as not all, and to be fair, most regulations and laws don't contain an affirmative obligation like this. Most leave it up to the enforcer to find the non-compliance, or the company to decide how to act if it learns of non-compliance. You know, from a quality perspective, do you do a stop sale? Do you have to recall it? Do you have to fix it going forward? But under this reporting requirement, you're required to immediately report to CPSC if you learn of any of this information. That reporting starts a conversation with CPSC about the problem. A firm can elect to recall the product without CPSC analysis, or it can work with CPSC to review the potential issue, at which point CPSC can request a recall. Failure to report can lead to penalties of up to $100,000 per violation, capped at $15 million for a related series of violations. There are upward adjustments of that number to account for inflation over time, so it's slightly more than those numbers, but that's the baseline. The real concern, and I really want to emphasize this reporting obligation as we talk about the overlap between these jurisdictions. This is CPSC's preferred punishment method. They don't need to show any true or clear problem with a product. They just need to show that a company didn't report when it should have. It's very subjective, and in my experience, CPSC has 20/20 hindsight. And this obligation applies to everybody in the supply chain. So if a retailer learns of information that supports the conclusion that a product doesn't comply with a product safety rule, it can't just tell the supplier and think that it's done. It needs to make sure that the supplier has in fact reported, and so on up the line. Everybody is at risk as a result of this reporting requirement. And just a little bit of enforcement information on CPSC beyond investigations for failure to report and the highly publicized results of those investigations and the settlements. CPSC's primary enforcement measure for these chemicals laws appears to be preventing entry. So thousands of products are stopped by CBP and CPSC working together at the ports, and they test them for chemicals compliance. I'm sure most, if not all of you on the phone have had a product stopped at the port and checked for compliance. And as this chart shows, looking at the violations from 2012 to 2018, lead and phthalates are number 1 and number 3 on the violations list. So what we can infer from that is that either on the one hand, these are just areas where there's lots of non-compliance. On the other hand, these are areas where CPSC is spending a lot more time enforcing. So be mindful of that when you're making decisions about compliance, that lead and phthalates in children's products are really these key provisions that are being looked at by CPSC. All right, moving on to state chemical requirements, I will start with the dreaded Prop 65. This is by far the compliance area where I get the most questions, and I think probably the most anxiety. I feel the most anxiety from my clients and most concerns about what to do. There is no silver bullet to compliance, and everybody does it a slightly different way. Before we talk about the approach to compliance, let's just go through what Prop 65 requires a little bit. So the full name of Prop 65 is the California Safe Drinking Water and Toxic Enforcement Act. The reason it's referred to as Prop 65 is because it was a public proposition back in 1986. So basically the people of California put it on a ballot, it passed the ballot, and it became law, but we still refer to it as Prop 65. It prohibits the knowing and intentional exposure, and I emphasize exposure, keep that in mind as we go through these slides, to listed chemicals without a clear and reasonable warning. As of now, there's approximately 950 chemicals on the Prop 65 list. It grows frequently. There are certain compulsory requirements when information comes out about chemicals that gets them on the list. The agency that administers Prop 65, the Office of Environmental Health Hazard Assessment, or OEHA, as it's called for short, evaluates chemicals as well and can add them to the list. The basic requirement for a plaintiff is to show an exposure, meaning only that a chemical comes out of a product and gets into a person. And then the burden shifts to the defendant in enforcement action to prove the exposure does not require a warning. Now, in all of my conversations with all of you about Prop 65, I understand that it is a vile and hated law. I am not in any way here to advocate on it, but I did want to give you a little bit of context, which is the origins of Prop 65 back in the 80s. It was common for industries to dispose of chemicals into water, directly to sewers, to emit chemicals into the air and not thoroughly advise their employees of the chemicals in their workplace. There was a sense that people didn't know enough about the products they were around, and that needed to change. I think back in the 80s, the expectation was that this law would be used to inform people of what was going on. They really didn't anticipate that it would, in the future, be used to require warning language on rubber duckies. So, I talked about exposure a bunch. The key to understanding Prop 65 is exposure. In contrast to CPSIA lead and phthalates requirements that are about composition, the question of exposure is very basic. How much of the chemical is in the product, how much of the chemical gets out of the product, and how much of the chemical gets into people based on those first two components. Under the law, it requires scientific analysis of the product and an understanding of how average users use the product. This is actually done through, it is required to be done through expert testimony or expert witnesses. This expert requirement and the scientific analysis is one of the main reasons that these cases settle and why people just follow settlement limits that the labs give them rather than thinking about exposure. An exposure analysis is expensive, it's product specific, and you likely have to litigate a case to conclusion to prove you didn't need to warn. And so while your expert will almost certainly say that the amount of exposure doesn't require a warning, the plaintiff's expert will say the opposite. So that is why we see so many Prop 65 settlements. The other ill that most of you are probably aware of in connection with Prop 65 is that it contains a private attorney general provision that permits anyone to bring a claim on behalf of the people of the state of California for a violation. And when a private plaintiff brings a case on behalf of the state, in addition to civil penalties that are authorized under Prop 65, the successful plaintiff will get attorney's fees. That's created a cottage industry of plaintiffs' lawyers who bring these cases really, I mean, some say, well, some are mission-driven or say they're mission-driven, some are just money-driven, but ultimately, there's a great incentive for lawyers to be bringing these cases. And again, because the cost of litigation is so high, because you need to have this scientific approach to exposure to bring a case, the plaintiffs settle these cases at pain thresholds that are well below the cost of litigation. So I've just popped up here some data here on 2018 settlements. You can see some of the common players in Prop 65, the number of cases they settled in 2018, and the amount of money that they took out of those cases. So you see the incentive in play just looking at this. I also want to point out this average here could be helpful to you. If you're dealing with your own Prop 65 compliance issue, these averages of settlements can be helpful in terms of gauging what your exposure is and also what a reasonable settlement might be or what the plaintiff will accept. Some Prop 65 enforcement trends that we're seeing. Lots of new enforcers. We're seeing new parties in the game. In terms of product and chemical perspectives, phthalates are very hot right now in terms of enforcement in a variety of products. Big one, I cannot emphasize this to you enough, is packaging, especially reusable vinyl bags or clear plastic packaging. You're seeing lots of notices being served over phthalates in packaging. This also applies to fashion accessories, so like vinyl handbags, backpacks. The trend towards clear bags is driving some more enforcement. We also see a lot of work in the area in terms of dietary supplements, lead and cadmium in those. A relatively new trend is hexavalent chromium in leather goods. Hexavalent chromium is used as part of the tanning process, and there are remnants that remain in leather goods. We're seeing PCBs in feminine hygiene and paper products, and PFOA in cosmetics. Just to call out here, PFAS is a family of chemicals that are used in a variety of products are really becoming a priority, appears, for enforcers, not just from a Prop 65 perspective, but more generally in environmental law. So something to look at and think about in terms of your products. The cases so far tend to be in cosmetics, but these chemicals are also in cookware and other types of products where non-stick properties are beneficial. So one interesting aspect of Prop 65 is that in recognition of the perceived abuses of the law by the plaintiffs' bar, there is an effort to revise the law in such a way as to reduce some of those abuses. The changes that we saw, these came into effect for products manufactured on and after August 30th of 2018, so they're in effect now. The major changes were adjustments to allocation of responsibility. So prior to these changes, everybody in the supply chain was equally culpable or potentially equally liable under the law, which gave plaintiffs a lot of leverage to sort of use supply chain relationships to force results. Now there's an allocation of responsibility that establishes priority from manufacturer to importer to private labeler and then ultimately the retailer. Under this allocation of responsibility, the manufacturer, producer, packager, importer, distributor is required to label the product or, in the alternative, provide written notice of the need for a warning to the retailer and also provide those warning materials. Under the regulations, consent is not needed. Retailer doesn't have to agree to do it. They just have to be notified. But in reality, communication and agreement within the supply chain is key. So just sending a notice is probably not going to make your retail customer happy if you're a supplier. You probably want to be talking about the way that they need to get that information and whether, in fact, they can do what you want them to do logistically. Allocation of responsibility can be changed by contract. So effectively, the parties in the supply chain can agree how compliance is going to happen. But at the end of the day, the consumer must still receive the warning. So it doesn't really matter if you allocate responsibility by contract if the warning is not received. The one benefit in terms of the amendment was a 5 business day cure period for pure retailers if the supplier is exempt, meaning the supplier is overseas or too small. 10 or fewer employees is an exempt supplier, and the retailer had no prior actual knowledge of the need for a warning. So in this example, a business that is just a retailer, they're selling somebody else's product, if they had no knowledge of the need for a warning and the supplier of that product is exempt, if they give the warning themselves after receiving a 60-day notice or pull the product from sale, they cannot be pursued under Prop 65. Emphasis here on pure retailer, the cure period option does not apply to private label products. So if you're a retailer that's selling private label products, you're effectively, the regulators put you in the shoes of the manufacturer or the supplier. There are other changes included revisions to the safe harbor warning regulation, what is deemed compliant. Prior to these regulations, if you were here in California, you'd see signs everywhere, labels everywhere that say, warning, this product contains a chemical known to the state of California to cause cancer or reproductive harm. The regulations changed to create a new safe harbor warning, which is warning this product can expose you to chemicals, including blank there. You have to identify a chemical and also include a link to some OEHA web pages that provide further information. I want to point out when I use the term safe harbor, this is a regulation that establishes what is deemed to be compliant under Prop 65. You can do other things. It's just possible someone will challenge you. But if you do it this way, you are within the safe harbor. There are also some specific requirements about how to warn for particular products, and the changes in the regulation leave existing consent judgments in place. The amended regulations are a very complicated process, and so if you are not aware of them yet, I think you should probably take some time outside of this presentation to learn a bit more about them. They include other types of requirements like e-com warnings on websites, catalog warning requirements, and so on. From a trend perspective, it's only been about 7 months since the law came into effect, maybe a little bit more. We're not really seeing much changing, at least not yet. We've seen some plaintiffs using, most of the plaintiffs we see in the Prop 65 community are using the same MO as before. Although we do see some plaintiffs who are noticing retailers and then they immediately request supplier identification. So they are using the allocation of responsibility angle to get to a supplier from the retailer. We also are seeing, just like I mentioned, the practical perspective about communication between the suppliers and retailers, but we're seeing some conflict between retailers who have set rules about how they want to receive warnings and suppliers complying with those warnings. So at the beginning or in preparation for these changes, there's lots of communication about what retailers wanted and about what suppliers wanted to give. And now we're starting to see that some of those things are starting to grate. So again, emphasis on communication in the supply chain. And so far, we are not seeing any challenges based on e-commerce warnings or catalog warnings. If a warning is being given, we're not seeing the cases. If there's no warning anywhere and the product contains the chemical, we're seeing cases just like before. Okay, turning to the next tranche of state chemistry or chemical requirements, we have a variety of state children's product reporting laws and regulations. The primary ones are Washington, Oregon, Vermont, Maine, and California. One note I want to make about these laws, part of the reason I think we're seeing these reporting laws is that there are preemption issues between federal and state law. So the way that our legal system works, if a federal law establishes a requirement and that effectively becomes the law of the land, and if a state enacts a requirement that conflicts with that law, then it is preempted. Well, arguably it is preempted. Sometimes it requires litigation to prove that it is preempted. But in this case, existing federal law didn't cover this area of reporting. So a number of states seem to get around the preemption issue by going forward with reporting laws. These laws are aimed at children's products. They require companies to report products to a public database, identifying chemical amounts, where the chemical is located, what its function is. As we think about, taking a step back. As we think about these laws, again, focuses on the preemption issue. So a number of states were in the process of establishing their own chemical compliance requirements. And then when CPSIA came online, they stepped back and they adjusted them and focused just on this reporting issue. I'm going to do a quick overview of each of these state laws. Again, they do interact in particular ways. They require more or less all the same information. So first you have the Washington Children's Safe Product Act. This is, I think, the most well-known of the state laws. It requires annual reporting for children's products that contain designated chemicals. The term is chemicals of high concern to children. It applies to chemicals on the list that are intentionally added or are contaminants above 100 parts per million. There are more than 80 chemicals on the list right now, and as I mentioned earlier, the report will include chemical identification, location in the product, function of the chemical, and the amount. Following from Washington, we have the Oregon Toxic Free Kids Act. It is substantially similar to Washington's requirements, but one of the really key differences is that Oregon requires a report for inaccessible components, not just accessible components. So under CPSIA, as well as under Washington, there's this question of accessibility. Can a child actually get to or otherwise be exposed to the chemical where it's located? Oregon says we don't care where it is. We don't care if kids can get to it. We want to know if there are chemicals and inaccessible components. Otherwise, the reporting and the reporting requirements and the information required are generally the same. One other wrinkle is that Oregon mandates phase out of chemicals in certain children's products within 6 years of the initial report. So we're looking at mouthable products intended for children 3 and under applied to the skin. So if you have a chemical in one of those products on the list and you're reporting it within 6 years, you're supposed to phase that out. It's not clear yet exactly how that process is going to work. We're still looking for guidance from Washington on that, and there's also, or from Oregon on that, and there's also a payment that has to be made in connection with a report. So after Washington and Oregon, Vermont got into the game with the Vermont Toxic Free Families Act. It is similar to Washington and Oregon. It requires reporting of chemicals just like the others. The one wrinkle here is that it actually requires reporting information in a different way. Washington and Oregon require reports by company and then by product and by chemical. Vermont actually requires reporting by chemical, and then you list all the products. It just makes it a little bit complicated in terms of the ministerial work that goes into it. There have been some recent amendments to this, and so now the next reporting deadline is now August 31, 2020, and that will cover all products sold between September 1, 2018 and August 31, 2020. Then reports are required every 2 years after that. Next, we have the Maine Safer Chemicals and Children's Products Act. This one is interesting because unlike the others, which establish a big list of chemicals and then require reports, Maine's law requires a one-time report for what are deemed priority chemicals. So the state actually passes a rule that identifies a chemical and the types of products in which it's in, and then requires reported information on that. On the slide, you'll see the chemicals that are currently covered, and these reports are required in nearly all types of children's products. And right now, PFOS or PFAS is pending, is a draft rule that will require reporting for PFAS. That is one of those chemicals like PFOA that I was talking about in the larger family of PFAs is the family. So PFOS and PFOA they're all kind of under the same chemical family. So that's further showing that this is a new hot chemical, and we should expect to see more and more regulations. And finally, we have the California Safer Consumer Products Regulation, which is different than all the other ones in that it doesn't just require reporting, it actually requires an alternatives analysis or market removal of a product if it contains a particular chemical. So in the California regime, there's a list of chemicals that are potentially at issue, and then an administrative body passes a regulation that identifies a type of product and a type of chemical. Once those regulations go into effect, it triggers the requirement for an alternatives analysis, meaning is there some other chemical that is less harmful to human health or the environment than the chemical at issue? And if the answer is no, then the government at that point can regulate the chemical and potentially place restrictions on it. If there is a safer alternative, then the government can require people to shift into that area. Right now, there are only 3 product chemical combinations listed there. Primary one, I'm assuming, for consumer products companies are flame retardants in children's foam bedding. But we have pending product chemical combinations in other products. So PFAS, I mentioned that earlier, surfactant in carpets and rugs, laundry detergent containing NPEs, paint varnish strippers and graffiti movers containing NMP, nail products containing toluene, and then the newest, which is still within the comment period, is 1,4-dioxane in personal care and cleaning products. So lots of requirements in these different states. The big question, drawing back to those earlier slides for context, is what about enforcement? So far, we're not seeing much. Part of the reason for this, I believe, is that the states have made much fanfare about the laws, but then given them limited resources and headcount for implementation and enforcement. We've seen some inquiries by Washington where they've clearly gone out into the market, bought some products, tested them, and felt that somebody should have reported it. We are aware that Vermont reviews the Washington list and the Oregon list when they're public, and have reached out to people and said, hey, you need to report to us too. Generally speaking, we've seen no public information on any penalties for non-compliance. My sense is that we are very much in a period of implementation and fixing problems. There is an effort underway to align, for the states to align with each other. And given the relative newness of these laws, it seems that the regulators are much more focused on using carrots for compliance and not sticks. So the reason I share this information is that if you think about all the things that you need to do to comply, it's important to prioritize based on the level of enforcement. So I'm not in any way suggesting that you shouldn't comply with these laws. I'm just letting you know that if you have to make some hard choices about what to do first, so far I just don't see enforcement in these areas. Over the next couple of slides, I've just listed out some additional state chemical requirements that I think are complicated, difficult, and something to be thinking about depending upon the type of products that you make. First and foremost, we have the California metal containing jewelry law. It covers lead and cadmium limits. This law actually came out of a industry-wide settlement under Prop 65. And the compliance levels vary for lead depending upon the type of metal, and they set requirements for 75 parts per million cadmium in children's products. There is current pending legislation that would revise the limits in this law and make the lead requirements much more stringent. So it's just something to be mindful of and keep your eye on. It's currently in committee, so we don't know whether it's going to pass, but there would be some dramatic changes in the requirements. The toxics in packaging model rule, which is a model rule which then has been implemented by a number of states. It limits heavy metals in product packaging. Can't have any intentionally added cadmium, lead, mercury, or hexavalent chromium in packaging. That includes, your cardboard, your cellophane, wrapping, stuffing, anything that's in there is potentially subject to this. In addition to the reporting requirements we discussed for Washington, the Children's Safe Product Act has some restrictions for lead, phthalates, and cadmium in children's products. I think one of the really interesting points about this Washington law is I mentioned preemption earlier, and initially the Attorney General in Washington took the position that CPSIA preempted all of these limitations in Washington's Children's Safe Product Act. But once the first reporting was published, the first product reporting was published, a number of NGOs looked at that and said, Washington, you have companies that are telling you they have more than these allowed chemical limits in certain types of products that are not covered by CPSIA. We think that you should be enforcing, and if not, we're going to sue you. And very quietly and unexpectedly, the state did a 180 and started sending letters out to folks who had reported noncompliance, saying you need to be compliant. Still haven't seen enforcement on that, just a mention to, just a nudge to get compliant. Beyond Washington, you have the Illinois Lead Poisoning Prevention Act. It requires some specified warning language on children's products and general use products. In the many years since that law has been in effect, I'm not aware of any specific enforcement on that. We have a number of California flammability requirements, as well as Washington and other states that limit the use of flame retardants in a number of products and in a number of jurisdictions. Okay, finally, the third rung here, local chemical requirements. So we're seeing a recent trend of cities and counties regulating chemicals directly. As I mentioned before with preemption, they face preemption challenges, not just from the federal government, but from state governments. The main reason that I understand these laws go into effect is that they provide enforcement capability to these local jurisdictions. So it's basically the idea is that some of these communities feel that federal and state government aren't doing enough to enforce these, particularly children's product laws. And so they pass comparable laws to give themselves enforcement power. Scope is typically limited. You're looking in the potential enforcement, you're looking at, units sold in a county. So certainly the exposure is probably much less, and it may not really warrant the amount of time and cost internally to get compliant. But beyond the cost of enforcement or responding to enforcement, these definitely compliance with these laws come with a clear PR and reputational risk. Attention at a county level not only looks bad, on social media, but it also could drive inquiries at the state and federal level. So a county could be tipping off a state DA that they should come after you for something. So just something to think about. And we've seen some examples of this where we've seen stories about cadmium and jewelry in California lead attorney generals in other states to investigate companies named in those California news stories. So something to bear in mind. Specific local chemical requirements, there's the New York County chemical composition laws. The original ordinances contained stringent requirements that went beyond what was required at the federal level. Following some challenges and lawsuits, they've scaled back, and for the most part, they either abandoned those requirements or they're synced up directly to federal law. So in that case, they're getting enforcement authority, even though the laws are the same. So you might avoid compliance issues at the port, but you could face compliance issues in a New York County. San Francisco and Anchorage have imposed and enacted flame retardant bans, which have created a lot of headaches and complications. San Francisco is focused on PFAS and has banned PFAS and polystyrene in food serviceware. and numerous cities and counties are implementing glyphosate bans. So, so far we're seeing that limited to bans in public spaces. So they're not going to be using those chemicals on parks, playgrounds, and schoolyards, but it doesn't take a lot of imagination to see a leap to other types of products. So, question on chemical requirements, and a key question is who's responsible? So as I've talked about some of these, I pointed out situations when they apply to anyone in the supply chain. It's really important that you review these laws and understand who is responsible. So is the obligation to comply on the manufacturer or the importer, or is it on the whole supply chain? You know, my recommendation is you almost have to think about these obligations geometrically. So CPSIA does not require a retailer to review certificates of compliance. You know, the obligation is on the domestic manufacturer importer to certify, but the retailer then gets visibility to the product itself. So retailer gets visibility into return rates, claims information, customer feedback. That information may give rise to knowledge at the retail level that triggers action. So supplier certifies it, but the market is saying something is wrong. It's important to bear that in mind as you're thinking about compliance. And this table here just lists out responsible entity information, potential penalties, and who the enforcers would be. You could use this as a key, if you will, for some of the high-level compliance issues out there. So just a couple other multi-jurisdictional risks I'm not going to go over in detail. You have packaging and labeling requirements. They're not chemical specific, but they do apply to a number of products across jurisdictions. You have pesticide safety registration and licensing requirements at both the federal EPA and state levels. VOC content in consumer products is a big deal in California. There are a number of other states that adopt California's compliance limits, but they don't really seem to be enforcing out there. And then, of course, we have formaldehyde and composite wood, both at the EPA and California level. From an enforcement perspective, we're seeing a recent trend where California is starting to enforce not just in furniture, but in home decor. So think about things that hang on the wall. That is a new move. The first rung of enforcement was on engineered wood, hardwood flooring, and we expected furniture would be next, which it was, but now home decor seems to be on the table. So if you're not selling furniture, you might have thought this didn't apply to you, but if you are selling home decor items, you could be looking at enforcement action in the not too distant future. So strategies for compliance. But the reality is you can't do everything. You know, even the most committed company cannot apply equal and appropriate resources to every single requirement. Even if they did, there would still be mistakes. So what are you supposed to do? My recommendation is that you concentrate your efforts on areas with high safety and enforcement risk, and then kind of expand outward. So if you look at this slide here, I have enforcement risk and safety risk plotted on the X and Y axis, and you see that green box, which is highest safety risk to the user and highest enforcement risk for the regulator, should 100% be focusing on getting compliant there and then expand outward. The green box really is a must, but you should, of course, strive to expand beyond it. And when I talk about enforcement risk here on that axis, I'm not just talking about public enforcers or private enforcers, but also reputational risk. So an approach to untangling the web or addressing these multi-jurisdictional laws. These are factors that I think are crucial to figuring out what to do here. You need to understand the risk profile, you need to determine a compliance approach, you need to think holistically, you need to standardize, you need to review and audit, and you need to build a knowledge base. I'm going to go through each one of these quickly. We're getting near the end of our time. So understanding your risk profile is key here. Compliance is necessarily tied to the business model. How does your company succeed? What type of company are you? Are you a luxury brand? Are you a discounter? Does your company make a lot of representations about social compliance or green products? Are you operating in the e-com space, brick and mortar, or both? And are you national or are you regional? What types of products do you sell? As we've just gone through, children's products are really the highest risk right now. Beyond that, we have health-related and food items, which are also big from an enforcement perspective. Do you sell a few types of products or everything? And is your product portfolio static, or are you constantly adding new products to the mix? And then finally, are you private label and direct sourcing your products, or are you just getting them from another supplier? And if you are the supplier, all of these factors tie in as well to your retail customers. So in your approach to compliance, you need to be considering who your customers are and how they succeed, because that is going to drive what's important to them and therefore drive what should be important to you. At the internal or compliance level, who is in charge at the company? Is it merchants and buyers, or is it compliance, and legal? I would bet that for most companies, the merchants and the buyers, have the final say, but I'm seeing a trend where compliance, legal, and risk are getting more and more of a voice and potentially veto power over some risky choices. What does your budget look like? Is the budget driven by preventative measures? Do you have to actually demonstrate return on investment for compliance? All these factors are going to tie into how much money and headcount you have to implement compliance. Who are your suppliers? This applies to everyone in the supply chain. So if you're the retailer, are your suppliers domestic or overseas? If you are the manufacturer and you're domestic, are your raw materials coming from within the US or overseas? That's going to change your leverage in terms of resolving problems, and also change who's responsible for compliance at the end of the day with a regulator. So in terms of compliance approach, there's a number of different ways to think about compliance. And they're really going to be driven by some of those risk factors I discussed before, and who you are as a company. So we've given some pithy names here that we like to characterize compliance programs. You have the one size fits all, which is on the one end of the spectrum, you can have an RSL that just says if you're giving us a product or you're making a product, it can't have any of these chemicals, or it can't have more than a certain amount. On the other end of the spectrum, you can focus on an approach where you're just getting your minimums covered. So what are the most specific requirements with the highest enforcement or safety risk, and then applying those across all of your raw material suppliers if you're a manufacturer, and all of your vendors if you're a retailer. Above and beyond, you're looking at your legal requirements, but also factoring in industry standards and best practices. This is for the supply chain that is representing to its customers that it is very focused on green issues, CSR issues, product safety. Of course, there's the hear no evil, see no evil, which is if you're not getting complaints, you're not seeing problems, then you don't do anything. And then finally, there's firefighting and band-aids, which is when you get into trouble, at that point you address compliance as to that trouble, but you're not really looking at what else is going on in terms of compliance outside that specific area. I would like to, I want to point out that there is also, in developing a compliance program, a huge difference between internal and external resources. So when your resources are limited, differentiating between internal and external approaches can help. So I've given some examples here, external resources or external efforts, supplier-facing documents that require your suppliers to do something. But internally, you can educate stakeholders on different types of requirements and really focus on what's key here. From an external perspective, the vendor is going to be responsible for testing for compliance, but internally, a company can audit products by periodically testing what they're receiving from the suppliers. The cost and benefits of external and internal efforts can swing drastically. So if you don't think you can get some policy in place that's external, I wouldn't stop there. See if there's a low-cost effort internally that can get you some incremental compliance benefit. Next key is thinking holistically. So, a common mistake is focusing only on a specific type of non-compliance. But because these multi-jurisdictional requirements are so tangled, you really need to think holistically. Tunnel vision is going to lead to mistakes. So, for example, you get a Prop 65 notice that alleges toys contain DEHP without providing a warning. What's the issue here from a holistic perspective? This probably creates a duty to investigate under CPSIA. Are you complying with the phthalate standard? And also potentially reporting to all those states we discussed before. So it's important, if you get triggered by one requirement, to think about the others. On the flip side, CPSC stops a product at the port. CPSC testing shows non-compliance. You should be thinking, have you sold the same product previously? Is the stoppage at the port is one issue, but do you have an issue hiding out because you previously sold the product? And does that create risk? Does the information you have on CPSC mean that you might have Prop 65 or state reporting risk, and should you take other actions? Standardizing. Standardization is another key to dealing with complex compliance regimes. Create a standard, then create an SOP for implementing that standard. The more complex a regulatory system is, the more opportunities there are for us humans to screw it up. So if you do the same task the same way every time, you decrease the risk of human involvement. If everybody knows their roles, everybody knows the decision points they have, and everybody knows how they need to talk to each other, then you decrease the potential for mistakes. Some opportunities I've listed there for standardizing approaches. How do you onboard new vendors or raw material suppliers? How do you do internal, external training? How do you do incident response, record keeping, documentation, and then your communications with regulators and consumers? Also crucial to review and audit. A common mistake is to make rules for compliance and then just kind of let it ride. And if nothing's happening, you're not hearing there's a problem, assume that it's working. It's really crucial to have continuous improvement processes in place. You can use the review and audit data to improve your processes over time. And it's important to not just think about reviewing and auditing, for example, the raw materials you're getting or the products that you're getting, but to review and audit your own internal systems and standards and see if they're working, and see if they're doing what you thought they would do when you put them in place, or see if they can be improved. Other benefits of review and audit is, you find problems before they become a regulatory problem. In the event of non-compliance, I find that if you have a system of review and audit and you're telling a regulator that you just missed this one, it's a mistake to the regulator or an error versus an endemic problem or a failure as a whole, on a whole as the company. And then of course it tells you whether your efforts are getting results. Finally, you really need a knowledge base. So these product safety laws and requirements, especially these chemicals laws and requirements, are constantly changing. There are changes to laws and regulations, changes to guidance, changes to enforcement. Some compliance resources, trade associations, labs, consultants, attorneys like me, peer benchmarking, blogs, newsletters, conferences, SPSP. All of these resources are out there for you to develop a knowledge base. And it's important, tying back to standardization, standardize that knowledge base. Put it somewhere where everybody can be accessing it that's involved in compliance, not just a folder on your hard drive that only you know about. So, covered a lot of terrain in the time allotted here. Thanks so much again for having me here today. And I'm not sure if we have time for questions. We'll just pose that question. Do we have time for questions?
Will, we don't have time for questions now, but we're going to have you answer those questions afterwards, and we're going to send them out to all the attendees here.
Great.
Or put them
Wonderful.
On our website.
Thank you so much.
Yes. Well, thank you, Will, and thank you to all of those that joined us today. The webinar recording will be available on our website by the end of this week, and as well as answers to your questions. And those of you who have submitted questions, please watch your email for responses, those that we weren't able to address during the presentation. In addition, please watch for announcements about upcoming webinars in the SPSP webinar series. Thank you, and you all have a wonderful day.